Welcome to Lawyer Up by NDV Law. I am Atty.Karlo Nicolas, one of the senior partners of Nicolas and the Vega law offices. We are going to discuss the topic on forgery of checks. If a check is forged under Philippine law, who bears the loss? The governing law is Act number 2031, known as the Negotiable Instruments Law of the Philippines. Section 18 of the Act says that no person is liable upon an instrument whose signature does not appear thereon. Therefore, you cannot make a person pay the amount of the check where his signature does not appear there. The question now is, what if his signature appears in the instrument but that signature was forged or falsified? Before a discussion of the rules on forgery of an instrument, it is best to classify the kinds of forgery that can take place. In case of promissory notes, forgeries may pertain to the signature of the maker or forgery of an endorsement. In case of bills of exchange, the forgery may pertain to the signature of the drawer, either by acceptance of the drawee or without acceptance but is paid by the drawee, and the forgery of an endorsement. Now here are the rules on forgery. Section 23 of the Negotiable Instruments Law provides, when a signature is forged or made without the authority of the person whose signature it purports to be, it is wholly inoperative, and no right to retain the instrument or to give a discharge therefore, or to enforce payment thereon against any party thereto, can be acquired through or under such signature, unless the party against whom it is sought to enforce such right is precluded from setting up the defense of forgery or want of authority. Now, in the case of Samsung versus Far East Bank and Trust Company, in 2004, the Supreme Court explained that a forged signature is wholly inoperative, and when the bank pays the check, it is paying out of its own money and not the depositors. The Supreme Court said the general rule to the effect is that a forged signature is wholly inoperative. If payment is made, the drawee cannot charge it to the drawer's account. The traditional justification for the results is that the drawee is in a superior position to detect a forgery because he has the maker's signature and is expected to know and compare it. Now, this rule of liability can be stated briefly in these words: the bank is bound to know the depositor's signature. But they all sum up to the proposition that a bank must know the signature of those whose general deposits it carries. In this case, therefore, the bank is liable. The court further added in the case of Samsung that even if the bank exerts due diligence, the bank is still liable. Hence, the court has this to say: on the premise that the signature of the check owner was indeed forged, it is the bank that is liable for the loss since it's authorized the discharge of the forged check. Such liability attaches even if the bank exerted due diligence and care in preventing that faulty discharge. Forgeries often deceive the eyes, and when a bank has been so deceived, it is a harsh rule which compels it to suffer, although no one has suffered by its being deceived. The forgery may be so near like genuine as to defy detection by the depositor itself, but the bank must be able to detect this and the depositor is not liable to pay. Consequently, if a bank pays a forged check, it must be considered as paying out of its own funds and cannot charge the amount it so paid to the account of the depositor. Therefore, the bank cannot pay the forged check, but the check can still be enforced between the issuer and the payee. This is stated in Section 23 of the Negotiable Instrument Law, which says that the instrument is not declared totally void, nor are the genuine signatures thereon rendered inoperative. It is only the forged signature that is declared inoperative. Therefore, rights still exist and may be enforced by virtue of the instrument between the parties whose signatures were not forged. A forged instrument just prevents any subsequent party from acquiring any rights, as against the party whose name appears prior to the forgery. Rights will still be existing and must be enforced between the parties who also have rights and may enforce them as against each other. So now I have answered the question. If a check is forged under Philippine law, who bears the loss? Thank you for watching this video. If this was helpful to you, please subscribe to our YouTube channel. Please also like our Facebook page, Nicolas and the Vega Law Offices. Finally, I'm inviting you to visit our website, ndvlaw.com, for more articles and information about Philippine law. I am Atty.Karlo Nicolas, Senior Partner of Nicolas and the Vega Law Offices. Thank you.